With profound respect, my lord.
I want to confirm first if you are all on this page so that you can then announce yourself. I've seen Mr. Hassan, I've seen Mr. Ochai, then who again?
Mr. S.A. Yelwa, my lord.
Okay, you are for?
I am for the second and the third defendants in this matter, my lord.
Okay. Are you all set?
Yes, my lord.
Yes, my lord.
Okay. Representation again, once again, please. Starting with the plaintiff's counsel.
With humility and respect, your lordship, I am Hassan S. Saraki. My humble appearance is for the plaintiff in this matter.
Okay.
Respectfully, my lords. My name is G. O. Ochai. My humble appearance is for the first defendant, my lord.
Okay.
With profound respect, my lord. My name is S.A. Yelwa. My humble appearance is for the second and the third defendants.
Yes. Yes.
Yes, my lord. Yes, my lord. The matter is slated to today for mention. And
Yes.
our processes have been duly served on all the respondents. Even though the respondents are yet to start for the defense.
Yes.
Yes. Just in this morning, I received a memorandum of appearance.
Counsel, I can't hear you. You said this morning you received
a memorandum of appearance from counsel to second and third defendant.
What did you receive? I didn't hear that.
Memorandum of appearance. We received memorandum of appearance.
It's very poor.
Hello, my lord, can you hear me?
Yes, just give me a minute.
Okay, sir.
Mm-hmm. Yes, you said you received this morning. Process, yes.
Memorandum of appearance.
Yes.
Of the second and third defendant.
Yes.
So
I don't
defendant,
like prompting you. You can see me looking at you. For God's sake, continue. Stop stressing me for prompting you. Yes, yes, yes. I don't want to be talking like that.
As court pleases.
I'm sorry. They are yet to file their defense. That is it, my lord.
Counsel, are you still there?
Yes, that's it, my lord. They are yet to file any defense. And they are supposed to file their defense alongside with the memo.
What you have received this morning a memorandum of appearance from the second and third defendant.
Yes, sir.
Yes,
yes,
then yes.
They are yet to file their defense. The defendant are yet to file their defense.
Yes.
Yes, my lord. And the matter is slated for mention. We are ready. That's our humble application.
Is that it? Plaintiff, is your case. I'm waiting for you.
Yes, my lord. I said we are ready for the matter to be mentioned. Subject to your convenience, my lord. My lord, we have filed originating summons before you, which is dated the 10th day of November, 2022.
Counsel, what exactly do you want?
For the matter to be mentioned, my lord.
Okay.
It is later for mention.
Okay. Go ahead.
The same has been duly served.
Yes, go ahead.
On all the defendants, my lord, in this matter.
Counsel, are you still there?
Yes, my lord. Same has been duly served on all the defendants.
Mr. Saraki, are you still there?
Yes, my lord. Can you hear me, my lord? Can you hear me, my lord?
We can hear you now, so proceed.
Yes, my lord. And same has been duly served on all the defendants.
I think you have to go back a bit. You have filed
Originating
an
summons
originating summons, yes.
dated the 10th day of November 2022.
Yes.
And was filed on the 11th day of November 2022. My lord, the state originating summons has been duly served on all the defendant in this case. We humbly we humbly present same as the case of the plaintiff. The result of this case, my lord.
I don't understand.
This is our humble application, my lord.
Any response to that?
My lord, I don't know whether we are to take date for hearing or council is actually moving his originating
I do not,
summons.
I myself, that.
My lord, I'm sorry, my lord. I'm not moving it, but rather I'm introducing the process that is before the court.
Counsel, although you have not appeared before me, you have appeared with another counsel.
Yes,
so you should be aware of how I work. There's no need for you to stress me into writing all this. All you said the matter is for mention. So have you exchanged processes? Should we move on forward? So all this, I'm not the one to impose, this is the way you should do your case.
Like, my lord.
You have introduced your matter. You said you want to introduce your processes. You have introduced it. What do you want?
That's it, my lord.
I think council should take a date for maybe either for
That's
further
what you're
mention.
supposed to do. You're just stressing us for nothing.
Let's go, please.
I'm sorry, my lord. I only introduced what is before the court, my lord. And I say that they are yet to file their defense. That's all.
So what do you want? It's your case. What do you want?
In the circumstances, my lord, then we should be applying for a date for hearing of the application.
Simple.
I should.
When? It's your case. Yes?
I thought, my lord, having introduced my case, and I informed this honorable court that they are yet to file defense, I thought my lord will now ask them. They should be the one to make an application and apply for the matter to be adjourned for hearing at their own instance.
If that is the way you want, it's okay by them. They can take a date to that here. It's your case. You need to know how. Anyway, it's your case. Council just agree on a date because you know this case is sui generis. Don't waste my time.
Yes, my lord.
Yes, what do you want? To what date?
May we be guided by the earliest convenient date, my lord, of the court. Earliest convenient date of the court.
When will this case lapse?
180 days. Right?
Oh, you still have time. Then take it to next year.
5th December, my lord.
Mustafa, give us a date.
My lord, is it December or next year?
Next year.
5th December, if you. Why are you interrupting?
Mustafa, give me a date next year if they can't make up their mind.
As the court pleases. In fact,
we are suggesting 5th December if it is convenient, my lord.
Who is talking?
my lord,
You are for who?
I am for the second and the third defendants in this case, my lord. My name is S.A. Yelwa, my lord.
So I know. Are you the one suggesting 5th December?
No, my lord, it is the counsel for the plaintiff that is suggesting 5th of December.
I want a date that you need to exchange all your processes.
Yes, yes, my lord. On our side,
I don't
we
want
only
you to come
file,
and waste my time like just.
as the court pleases. On our side, we file a memorandum of appearance, and we are making effort to do the needful, my lord, before the next adjourned date, so that
Give
this
me
matter.
a date, Mustafa, so that we can continue. We have other cases, they are not ready. Give me a date.
As the court pleases. As the court
Whenever
pleases.
they are ready, they can come to court.
As the court
As the court
pleases.
pleases.
My lord, 30th January.
30th January.
Yes, my lord.
Okay.
What? Don't do it.
This matter is hereby adjourned to 30th day of January 2023 for definite hearing.
As God please.
As the court pleases.
Thank you, gentlemen. Call the next case.
We are most grateful, my lord.
Pleases. Suit number FSC/DM/CR/54/2022 between the Federal Republic of Nigeria versus Awa Shaibu.
The presentation, please.
With utmost respect and humility to Her Lordship, my Lord, D.I. Indahi, my humble appearance is for the defendant applicant. May it please the court.
Respectfully, my Lord, my name is Usman Bamala. My humble appearance is for the respondent complainant.
Yes.
My Lord, subject to your convenience, we have an application by way of motion on notice, and we are ready to proceed.
My Lord, we are equally ready, my Lord.
Okay. Let's go ahead, counsel.
Thank you, my Lord. My Lord, the application is dated and filed on the 11th day of November 2022, respectively, and is brought pursuant to sections 158 and 165 of the Administration of Criminal Justice Act 2015, sections 35(4) and 36 of the 1999 Constitution, respectively, and the inherent powers and jurisdiction of this honorable court. My Lord, the application is praying for the following two reliefs as rightly indicated on the face of the motion paper. One, an order of this honorable court, my Lord, admitting the applicant on bail pending the final determination of the trial and charges against him in charge number 54 pending before this honorable court. My Lord, our second prayer is an omnibus order, and for such order or further order as this honorable court might deem fit to make, my Lord, in the circumstances. Your Lordship, sir, to save the time of this honorable court, my Lord, there have been no any objection or counter
Yes, go ahead.
to the applicant's application, my Lord. We wish to move in terms of the motion paper.
Counsel, just a minute. How many paragraphs of affidavit? I want to confirm.
9, my Lord.
9. Deposed to
9
by
with one.
annexure.
Deposed to by the litigation secretary with one annexure marked as Exhibit A, my Lord.
What's the name of the deponent?
Abdullahi Ibrahim Gambo,
Okay.
the litigation secretary of Ambro Chambers Zamatru.
Yes, okay.
My Lord, in compliance, would list our written address in support of the application and adopt all the submissions therein and the argument, and urge Her Lordship for the interest of justice. Thank you for the audience.
The substantive matter was adjourned to when?
My Lord, it's adjourned to 18th January 2023. Okay. 18th January 2023.
Okay. Thank you, counsel.
You're welcome, my Lord.
I'm sorry, my Lord. It's not 18 January. Here is 9th day of February.
9th February?
File. Yes, in the case file.
Okay.
Yes, my Lord.
Yes, I can see at the last adjourned date, it was adjourned to the 9th day of February, 2023.
Yes, ma'am.
Okay,
Yes, ma'am.
thank you, Registry of Court.
Thank you, madam.
Yes, prosecuting counsel. You have to unmute your phone. Yes.
Yes, my Lord. My Lord, we have not filed any counter to that issue, my Lord, and we are not objecting, my Lord.
Okay. Ruling.
As court, please.
The defendants Abdul Hamid Yahya and Kawa Shaibu were arraigned before this honorable court on a two-count indictment contained in a charge dated 17th October 2022 and filed 18th October 2022, and their plea taken on 20th October 2022. Both defendants pleaded not guilty to the two counts charge, and their counsel, D.I. Indahi Esquire, introduced the defendant's pending motion dated 11th November 2022 and filed same date. It was introduced today. The prayers reads, 1, an order of this honorable court admitting the applicants to bail pending the determination of the charges leveled against them, and 2, for such further orders or orders as this honorable court may deem fit to make in the circumstances. The defendant's motion on notice is supported by a 9-paragraph affidavit deposed to by one Abdullah Ibrahim Gambo, a litigation staff in the law office of the defendant counsel. In paragraphs 2, C, D, and E of the said affidavit, the deponent states facts that the applicant is ready, prepared, and willing to prosecute the case. While on bail, the deponent stated further that the defendant applicants are desirous to be released on bail pending trial and undertake not to commit an offense while on bail, and that it is in the overall interest of justice to grant this application, as the respondents will not be prejudiced by the granting of this application. The applicant defendant counsel, Mr. Indahi Esquire, filed a written address to argue the defendant's motion on notice, and in paragraph 3.01 of the address set down a sole issue for determination whether the applicant is entitled to the relief sought. Counsel answered his poser in the positive and argued that the applicant is entitled to the presumption of innocence and cited a couple of cases in support. The respondent prosecuting counsel, when served with the applicant's motion on notice, did not file any counter affidavit. This honorable court, having perused the processes filed by the applicant defendant counsel, comprising the motion paper, affidavit in support, and written address, as well as an annexure, will determine the application with the issue as formulated by the court, being whether the applicant in the affidavit has placed sufficient materials before this honorable court to be entitled to the favorable exercise of this honorable court's discretion to be granted bail pending his trial. The grant of bail is not one that is to be attended to mechanically or myopically without due consideration of the facts as presented in the application. The grant of bail is at the discretion of the court, and this is a fact born out of the communal reading of the provisions of section 158 to 163 and 165 on 167 sub 1 of the Administration of Criminal Justice Act 2015. Judicial discretion is a solemn exercise of one of the most potent judicial powers of court of law and should not be trivialized on an inglorious altar of observing the constitutional presumption of innocence in favor of an accused person by admitting him to bail on one hand, and on the other, to impose such terms and conditions which invariably will amount to taking back with the left hand that which the court has granted with the right hand. To do so will, in my view, be subversive of the solemnity of the judicial discretion which the court by law and the Constitution is entitled to exercise one way or the other. The court is entitled in the exercise of its inherent jurisdiction as prescribed by section 66A and B of the Constitution of the Federal Republic of Nigeria, 1999, to make judicial orders from the recognized and prescribed legal consequences of occasions when it arises, as in this instance. When I typed in the name of this case on my laptop, a similar name to the first defendant came up, signifying that he is standing trial on similar offenses, similar narcotic drugs and measurements. This information is stored in the laptop's memory. I now check the file in the system bearing the name of Abdulhamid Yahya, CR 15-2022, confirming that the first defendant is indeed before this court facing similar charges. and was granted bail when he came in through a fundamental rights procedure. It took a Herculean task to eventually arraign him before this honorable court. Notwithstanding, this honorable court granted the first defendant bail, and while on bail, he is alleged to have committed a similar offense. My worry is that the first defendant is before this court again with the second defendant, who is a very young person. I hope the first defendant is not one of those drug lords or individuals who are involved in criminal activities or contemplating getting or grooming younger boys to be involved or used as traffickers for a commission as fees. It is obvious that when this occurs, the court has not discharged its statutory duty well in ensuring that its discretion in granting bail strikes the delicate balance, which I've briefly analyzed and which are essentially sociological in nature, is not being abused. The fact that possessing and dealing in illicit drugs has been adjudged as an organized economic crime is the defendant, an old hand who feels that whenever he is arrested, he'll be arraigned, seeks for bail, and then readily go back to the same illicit business in the hope that even if he's caught, it's a question of a few months incarceration, and he'll be released to return to the business and make good money in illicit dealing and trading in drugs. I ask this question, taking account of the larger society's interests. The Supreme Court, per M.T. Muhammad, in the case of Dokubo Asari versus Federal Republic of Nigeria, 2007, NWLR, held that some of the required guidelines relevant to the determination of grant or refusal of bail to a defendant in matters of bail pending trial may not be admissible as evidence in the main trial, but they are certainly worthy to be taken into account in an application for bail pending trial. See also Bamayi versus State 2001, Abacha versus State 2002, Ekwangu versus Federal Republic of Nigeria 2001, AU versus State 1988, Antata versus IGP 1959, Abiola versus Federal Republic of Nigeria 1995, etc. Again, it is not automatic that once the charge is an indictable felony punishable as in this instance with a term of imprisonment, that bail will be granted. Whilst the jurisdiction the court exercises in bail applications is required to be so exercised liberally in order to give effect to the provisions and spirit of the Constitution, in particular, it's section 36(5), by which a defendant is presumed innocent until the contrary is established. The court is often concerned with one major issue in the guidelines. It is the prospects of the defendant returning to court to face his trial, where the hope is dim and there are no materials placed before the court to assuage the fear of the state that the defendant will be available to stand his trial. The court in deserving cases, even for such indictments such as this, will ex debito justitiae refuse to exercise his discretion in granting bail. The fundamental issue in all of this is the prospect that the defendants will be available to attend their trial whilst on bail. These are, in my view, the fluid nature of the jurisdiction that a court of first instance, whilst exercising its judicial powers on bail, which on the authorities it is required to exercise judicially and judiciously, should never find itself boxed, as it were, into a corner and thereby become inhibited in considering any applications which may be made to it in furtherance of its quest for justice. This is because the overall objective and goal of the court is to accord both parties a fair hearing and the defendant a fair trial. This honorable court, following in the reasoning of appellate courts vis-a-vis the instant bail application, taking the interest of the applicant defendant as well as the larger society's interest, which has a stake in every decision, the court must be alive to its environment, especially as it relates to the upsurge of violence vis-a-vis the prevalence of illegal possession of narcotics in the system. The Nigerian state is undergoing serious security challenges to a large extent the proliferation of narcotics and psychotropic substances are among the contributory factors we as a society are facing presently, especially when viewed through the prism of the security challenges bedeviling Yobe State. There's no court of law having regard to the provisions of sections 122 of the Evidence Act 2011, by which courts can take judicial notice of certain notorious facts that can shut its eyes to these incidents, as it will be an act of sheer judicial affectation to pretend as if all is well in terms of internal security in the state. And I'm aware of the principle that where a particular type of offense has become prevalent in an area where an application for bail is being taken, the court must be alive to its responsibilities or to its environment without prejudging any issue or denying the accused person or defendant his undoubted fundamental rights to presumption of innocence, in weighing the need to exercise his discretion one way or the other. While the first defendant is not being prejudged as a commercial dealer in narcotics, the fact that after being granted bail on a similar charge, the first defendant is before this court with the second defendant on similar charges. Now, the unrelenting or relenting orgy of violence and killings, which the usage of these narcotics has allegedly wreaked on a hapless nation and a defenseless and innocent citizenry, including kidnappings of people in this state and neighboring states, as well as killings wherein people are being killed in villages and wars on transit, are examples of incidents which no court of law can afford to ignore and treat as extraneous material, which need not be reflected upon while considering the applicant's motion or notice for bail. It is not that these incidents are to be used to deny bail to the defendants, but this court will fall short of being a court of law and of justice if it pretends that all is well in the polity in terms of security of lives and properties, which in the last few years have come under relentless and mindless onslaughts, allegedly by people who mastermind the sale and ingestion of narcotics. The main function of bail is to ensure, as stated earlier, the presence of the defendants at the trial. The Supreme Court, in the case of Dokubo Asari versus Federal Republic of Nigeria, Supra, held that this criterion is regarded as not only the omnibus one, but also the most important of all criterion for granting bail at the trial court. As a matter of fact, all other criterion are dependent on the omnibus criterion of availability of the accused person to stand trial. Arising directly from the omnibus criterion is a criterion of the nature and gravity of the offense. It is believed the more serious the offense, the greater the incentive to jump bail, although it's not invariably true. Whilst the court is concerned that the presumption of innocence of the defendants, which is constitutionally guaranteed, is protected, it must also ensure that the capacity of the state to enforce its criminal legislations against the defendants is not undermined by a casual approach to the grant of bail, which invariably may encourage persons sending trial to take advantage of the softness of the court to abscond, which has happened a number of times in this court. Once this happens so frequently, the capacity of the state to enforce its criminal legislations will be gravely undermined, and this itself becomes a security issue in the polity. The court is therefore required, whilst exercising its discretion, not only to do so judicially, but judiciously, by adverting its close attention to the materials placed before it. These are often deducible from the depositions filed and at times exhibits. While where there are exhibits attached in the instant case and in the course of this ruling, I've alluded to the upsurge of violence in this state, which is an extraneous material, but which the court must factor in or key in whilst exercising its judicial discretion. Whilst I agree that the issue of admitting or not admitting to the offense charge raised may not be a ground to grant bail pending trial. It is my view that the first defendant on his part has not provided sufficient material by which this court can come to a decision that the first defendant is entitled to a favorable exercise of the court's discretion. When I read paragraph 7A to F of the deponent affidavit filed in support of the defendant's undated motion on notice and the address, it is my view that the defendant, the first defendant has not provided this court, even with the provisions of section 162A to F of the Administration of Criminal Justice Act 2015. Supra, I read against the presentation by the prosecution with facts which can give any court a reasonable degree of assurance that the defendant, if granted bail, will be available to stand his trial. In common law or Commonwealth jurisdiction, is the prospect that the defendant will be available to stand their trial as one of the judicial guidelines laid down by the Apex Court. In a plethora of decisions that will determine the success or otherwise of an application as was filed by the defendant in the instant matter. The depositions in the affidavit in support are not, in my view, sufficient to give this court the kind of assurance it requires that if its discretion is exercised in favor of the defendant, of the first defendant, will be available to stand his trial. Let me again state that I'm not in any doubt that the offense alleged in the charge is a bailable offense, notwithstanding the seriousness of the offense and the severity of the punishment prescribed by law. And a refusal of bail does not remove the constitutional presumption of innocence in favor of a defendant. When all of these issues are taken together, I'm constrained and found it rather difficult to exercise my judicial discretion in favor of granting bail to the first defendant, considering the analysis I had done in the body of the ruling. Consequently, the application for bail filed and argued on behalf of the first defendant applicant is hereby refused for the reasons I've given in this ruling. In further consideration with the provisions of section 35 and 36 of the 1999 Constitution, supra, the courts will always want to exercise their discretion in favor of granting rather than refusing bail to a defendant accused of committing an offense which is not a capital offense. What the court requires, as stated earlier, is not for the defendant not to evade his trial, but for the attendance of the defendant in court. Consequently, bail is granted to the applicant's second defendant, one, in the sum of 3 million naira and 2 sureties in the like sum. 2, the first surety must be a traditional or religious leader in Yobe State. 3, the second surety must be a responsible member of the society from any sector. 4, the 2 sureties to stand for the defendant, for each of the defendants must be, for the defendant, I meant to say, must be resident in any of the local government capitals of Yobe State, and that fact must be verified by the NDLEA as reliable. 5, the 2 sureties shall each swear to an affidavit of means. 6, the defendant applicant together with both sureties must each deposit 2 copies of their recent passport photographs with the station registrar of this court. 7, the defense counsel shall write a formal letter to the station registrar, Federal High Court Damaturu, to introduce the respective sureties as responsible citizens to whom the court can safely release the defendant on bail, the second defendant on bail pending his trial. 8, the defendant is to provide a valid active bank account attached to a BVN number. This fact must be verified by the defendant counsel as having been complied with before the release of the applicant on bail. The application succeeds on the terms and conditions as prescribed. The second defendant Both the first and second defendants are to be remanded in Portisco Correctional Facility. The second defendant, pending when he fulfills the bail conditions. This matter is hereby adjourned on the concurrence of council to the 9th day of February 2023.
As God pleases. My Lord, we are much obliged and grateful with this sound ruling and the analysis therewith aimed at promoting the rule of law. May it please the court. Thank you, my Lord.
Thank you, counsel.
That's all for the day, my lord. Thank you.
Okay, thank you so much. Thank you, gentlemen.
Thank you,
my
my
Lord.
lord.
Magandai.
Alam Gobaro.
Sun tafi sun bar ne ko kuma suna nan ne?
Mu tambaye registrar.
Baya da mai.
To, thank you.
Na ce, to shi kenan. Sai yi magana waya ko.